On April 24th, 1970, deep beneath the earth at the Obuasi mine in the Ashanti region of Ghana, a 22-year-old track boy named GRUNSHIE stepped into what should have been a routine cage trip down the shaft. What happened next would spark a legal battle revealing how justice sometimes finds unexpected pathways to materialize. GRUNSHIE claimed he was the first in line for the industrial elevator that would carry workers down into the depths of the mine. The cage was designed for a maximum of 8 people, but on that day, he alleged that 14 workers had somehow been squeezed inside in the overcrowded descent as bodies pressed against each other and workers jostled for space. GRUNSHIE claimed he was pushed against the wall with devastating force. The impact fractured his humerus and sent him into shock. GRUNSHIE was convinced that AGC's negligence had caused his injuries, so he filed a suit in the Circuit Court of Kumasi. His case was straightforward, that AGC had allowed dangerous overcrowding and he had paid the price. On September 29, 1972, after careful examination of the evidence, the court delivered a crushing verdict. GRUNSHIE had failed to prove that 13 other people had climbed aboard the cage that day. The evidence showed only 8 people were present, exactly the safe capacity. More damaging still, the court found that GRUNSHIE would have remained unharmed if he had simply stood still with his arms by his side during the descent. His negligence claim therefore collapsed. GRUNSHIE had failed to establish the crucial link between his employer's alleged misconduct and his own injuries. Notwithstanding this, the trial judge, perhaps moved by the young man's suffering, awarded him 600 cedis in damages for his pain. There was a shocking twist. To put this in perspective, this sum represented more than 2 years of wages for someone earning just 95 pesos per day. Ashanti Gold's lawyers were incensed. In their view, the award made no legal sense. If there was no negligence, then there should be no damages. Even if some compensation was justified, they argued that 600 cedis was grossly excessive for pain and suffering, so they appealed the decision immediately. GRUNSHIE, meanwhile, refused to accept his earlier defeat on the negligence claim. Like Oliver Twist, he wanted more. He cross-appealed, insisting that Ashanti Gold had indeed been negligent and that his injuries were entirely their fault. The stage was then set for a complex legal battle that reached the Court of Appeal, led by the eminent Justice Giage. The appellate court first addressed GRUNSHIE's cross-appeal, and the conclusion was swift and merciless. Like any negligence claim, his case required proof of a link between the harm suffered and AGC's negligent act. He had failed to establish this connection, and his cross-appeal was dismissed without ceremony. The path now seemed clear for Ashanti Gold. If there was no negligence, then surely there was no lawful basis for them to pay any compensation. GRUNSHIE could walk away empty-handed, but the Court of Appeal was about to demonstrate that law contains more than one pathway to justice. While GRUNSHIE had failed to prove negligence, the court noted that his rights under the Workmen's Compensation Act, then of 1963, remained entirely unaffected. Under this law, even where an employer is not found liable for negligence, a determination could be made about compensation, and the facts were undeniable. GRUNSHIE was an employee of Ashanti Gold, and his accident had occurred during the course of his employment, and due to his injuries, he had been unable to work for months. Evidence showed that Ashanti Gold had indeed begun evaluating GRUNSHIE's injuries to determine compensation, but they appear to be seeking a reason to minimize their obligation. 3 medical officers, all employees of Ashanti Gold, had assessed GRUNSHIE and reached the same conclusion. They found no functional disability of any kind. Despite the pain he felt in his arms, he testified that GRUNSHIE could not possibly be injured, pointing out that he was back at post, still working his former job 8 months after the incident. GRUNSHIE was deeply troubled by these findings, and he sought independent opinions. At Konfanosi Teaching Hospital, Dr. Pubek, an orthopedic specialist, determined that he had suffered 30% disability. Seeking confirmation, GRUNSHIE obtained another evaluation from Dr. Roberts at a private clinic, which revealed an 18% disability. When GRUNSHIE testified about his ongoing difficulties, particularly his struggles working underground with his injured hand, his testimony could not be called into question. Cross-examination revealed even more damning evidence. It emerged that all of Ashanti Gold's doctors were general practitioners, lacking specialized orthopedic expertise. Though they contested the reports from Drs. Pubek and Roberts, even sending a delegation to verify the hospital's findings, they never sought independent opinions to support their position. The Court of Appeal saw through this corporate charade. All 3 appellate judges established that there was indeed proof that GRUNSHIE had suffered some sort of partial permanent incapacity. Therefore, the trial court's award of 600 cedis was not misplaced. It was in fact entirely justified under the compensation framework designed to protect workers. We learned a few lessons from this case. Sometimes, when one legal door closes, another may open. GRUNSHIE's failure to prove negligence was not the end of the story. The case revealed how employers might seek to minimize their responsibilities through one-sided medical opinions, the importance of independent evidence. In the end, Grunshi's journey from the depths of the Boasim mine to the Court of Appeal demonstrated that justice may tarry but can still find its way to those who genuinely need it. Follow Super Law J Studios for more real stories, real cases, real people.